I'm Cynthia Rowland, and this is episode 154 of EO Radio Show. In this episode, I welcome back my partner, Ben Buchwalter, to talk about changes in employment laws for California employers in the spring of 2026. Ben is passionate about advising employers on pragmatic and proactive employment programs to help California employers see around the corner and establish measures tailored to their goals and culture to minimize unacceptable employment risks. When disputes arise, he offers an experienced and steady hand toward resolving conflicts, and when necessary, vigorously defends his clients in federal and state courts and arbitrations and before administrative agencies. Ben and I work together for many of my nonprofit clients, and he's well aware of the special issues that come up with charities and their staff. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. So welcome back, Ben. It's good to see you.
Thank you. Thank you for having me.
So today's topic, we're going to do a spring 2026 employment law update for employers with employees in California. I always hesitate there because in this new post-COVID world, a lot of employers have employees everywhere. So this is for anybody who's employing California employees, right?
That's right. Even with people working remote, many employers do have people who are either located in California or work a substantial amount of their time in California. And for any of those folks, it will be important to make sure that all of the California laws are being followed. And also we'll be covering a few new federal standards today, which would apply to all employees.
Okay, so it looks like we've got 6 main topics. Do you want to give the listeners a preview of the 6 things we're going to talk about, and then we can go dive deep on each of them? That way we can we can grab people's interest, and if none of them apply, they can move on. And if one of the later ones do, maybe they'll hang in there for the entire episode.
That sounds perfect. So first of all, as happens every year, there has been a California minimum wage increase. So we'll address that and what it means. There is also a new California quote unquote stay or pay ban that limits employers from trying to keep employees on the payroll by threatening them that they have to pay something if they're going to leave early. There's also something called a Know Your Rights notice, which employers are required to give their employees about certain rights they have to workers' compensation or the right to notice of inspection by immigration agencies or some other things. There is an expanded eligibility for paid family leave in California to what's called a, quote, designated person. We'll talk about what that means. There is also a new federal joint employer standard. This is applicable to employers that maybe engage individuals through a third party to do work for them. It'll be really important to know what the standard is for whether you can be deemed their employer as well. And then finally, there's a California Supreme Court decision that I'd like to talk about for any employer that may have wage and hour claims. It's a decision that didn't get a lot of headlines, but has a huge impact on the right to claim a good faith defense to those wage and hour claims.
So that's going to cover a lot of territory. I do want to note for the listeners, we have prior episodes that Ben and I and some other employment lawyers at the firm have done about California employment laws. And there's some webinars, I think, on Farella YouTube channel if people want to hear more about these topics. So look for those in the show notes. Let's start in, I guess, the minimum wage thing. That's a good news one for employees, maybe not for employers, but let's start back at the top.
Absolutely. So the new minimum wage in California is $16.90. It may vary based on your city, too. Some cities impose a higher minimum wage. The main reason that this will be important for employers is if they're conducting an analysis to which of their employees should be classified as exempt or non-exempt. To classify employees as exempt, they would need to hit a certain minimum compensation. And so with that new minimum wage, the minimum compensation to be properly classified as exempt would be an annual salary of $70,304. That's kind of the most important takeaway from it.
But that, just to be clear, that minimum annual salary, if you hit that, that doesn't necessarily mean that you're exempt. It's just a threshold, bright line, objective number that you have to meet.
Exactly.
Gotcha.
If you don't hit that number, you know the employee cannot be exempt. If you do hit that number, then you would still need to conduct a fact-based analysis to make sure that that individual meets one of the categories that could be classified as exempt. Typically, that means that they exercise a high degree of independent judgment in their job rather than simply being told what to do by someone else.
Okay, great. And we could talk for hours just on those facts and circumstances, but we'll leave that. We probably have other episodes that go more in depth on that. But that's the update for spring of 2026. And that it took effect on January 1st, right?
That's right.
Okay, so let's talk about the stay or pay ban. That sounds snappy.
Yes, absolutely. It's got a snappy title, but what it basically means is, there have been times in the past when employers have imposed rules on employees saying, we expect you to stay until, let's say, December 31st of this year. We're relying on you to do that. If you leave before December 31st, it's going to hurt us so much that we're going to impose some kind of penalty or fine on you for leaving early. The California legislature said unilaterally that is not okay. You're not allowed to just impose penalties on people out of nowhere because they're exercising their right to work wherever they want. Now, this is actually very consistent with what we've seen in California over the past 10, 20 years. California has repeatedly shown that it is not interested in restraints in trade. We have a fundamental public policy in the state saying that people should be able to work wherever they want to work. Now, that said, there are a couple of key exceptions, I think common sense exceptions to this law. One of them is if there's a sign-on bonus that an employer gives to someone at the beginning of employment that is set out in a separate agreement from their employment contract. And they say, we're going to pay you, let's say, $15,000 to join us, so long as you're with us for at least a year or 2 years or whatever the term is. That is okay as long as it's in a separate agreement from the offer letter. The other key exception is for tuition that the employer provides for employees. There's certain types of training that they're not allowed to recoup the costs of. For example, if they're training an employee about, how to be safe in the workplace, that is part of the job and you wouldn't be able to recoup that cost. But if you're sending an employee to university to get certain training, that is considered above and beyond an employer's normal responsibilities. So as long as that is set out in a separate agreement saying this is an additional benefit we're providing for you, it costs this amount of money. In return, we expect you to stay a certain amount of time. That could be recovered if the employee leaves earlier.
Although as a practical matter, recovering from employees, unless you can take it out of that final paycheck, chasing an employee to write you a check as an employer seems difficult.
It is difficult. It's almost never a good use of the employer's time to go after an employee. Oftentimes it means the employer needs to file a claim in small claims court. And in small claims court, you're not allowed to have a separate attorney handling your matters. You need to do it directly. So you're both, spending time doing it, and you're also incurring the costs of going to small claims court. So like you mentioned, it's usually not a good use of an employer's time, but if the amount is significant enough, or if there's enough employees at issue where the amount added together is significant enough, it may become a consideration.
Yeah, so the better strategy probably to keep, if you want to induce employees to stay, is to offer, instead of paying up front, pay it as a bonus at the end, whenever, if they stay X number months after they complete the training or whatever it is. Okay, well, interesting to know. Our next thing is another notice. How many notices do California employers have to post on the wall?
Constant. And it's not just posting on the wall. It's often notices that you actually have to affirmatively send to the person, either by email or in their onboarding packet. It really is a lot that California employers are expected to do. But this one, it's actually an update to an existing notice. existing law required California employers to provide what's called a Know Your Rights form to employees. And that the update this year as of February 2026 was that needed to include a reference to workers' compensation benefits, the right to notice of inspection by immigration agencies, and an opportunity to name an emergency contact to specify if that person can be contacted upon the employee's arrest or detention. Now, this is obviously a change that is connected to what's going on at the federal level as well with increased immigration enforcement. And California seems to be making a policy decision that, we want our employees to at least have the opportunity to know that this is happening and make sure that their affairs are in order.
Okay, that seems like a very useful thing to add. So when these sorts of things change and update to the notices, that takes effect immediately? And so you get a special notice out to everybody?
So this law was passed at the end of 2025, and they included certain time horizons for when each thing would take effect. So these updates to the notice went into effect in February. So there was some time period where people had time to prepare. And then the right to have an emergency contact, that kicked in on March 30th, 2026. It was not retroactive, so it doesn't mean there's penalties for not doing it before. But for any employers who haven't yet implemented these changes, now is a good time to do so.
Okay, good to know. Expanded eligibility for family leave, that seems like a good thing.
Yeah, this is another positive for employees. The California law related to family leave already has a very specific list about who it can be taken for. And it's kind of what's considered close family members, right? Your mom, your dad, your kids. But beyond, very close family members, it's been a little bit vague about what's included. So what the California legislature did this year is they said, well, we're not going to expand it to include everyone in your family, everyone under the sun, but we're going to say you can identify what's called a designated person who has to be related to you by blood, but it's still someone who's in your family, maybe not part of that close unit, but as part of your family that you can also take paid family leave for. Mm-hmm. So if you have, a second cousin thrice removed, and that's someone who's incredibly close to you, you could take paid family leave to care for that person.
So is there a limit on how much leave time? There must be some limit. It's just not an unlimited number of days.
No, yeah, there is a limit. It depends on the location, but, the California leave standard and the federal leave standard would be 12 weeks of unpaid leave. Mm-hmm. And then the amount of it that's paid is typically around 6 weeks at a minimum, and then it may vary depending on the location. I should note that the amount that would be provided to the employee is typically up to 60% of their salary that would come from the state. And then some locations would true it up to 100%. Like, for example, in San Francisco, for if you're taking paid family leave for baby bonding, the city of San Francisco would true that up to 100%, up to a certain limit.
Okay, so it doesn't come out of the employer's pocket. It just says you have to hold the job for this person and they can take the leave.
That's right.
Well, that's good news for employees and just more to notice if you're an employer. Mm-hmm. Okay, so now I think we shift to change in the federal law.
Yes, this has been kind of a fascinating ping-ponging back and forth in the joint employer standard between the Biden administration and the Trump administration. When the in the first Trump administration term, they changed the joint employer standard to apply to any employer who had, quote, substantial direct and immediate control over a worker. Backing up a little bit, what this means is that if there's an employer who has a worker on site who is actually employed by a third party, maybe you contract through another company who makes sure that they provide those workers, in certain circumstances, the company who is actually directing the work might be deemed to be that person's employer, even if they're not on the offer letter or any of the employment documents. And that can be a real burden for many California employers who were just trying to enter into a contracting relationship with another company. So under the Trump administration standard, it was generally considered better for employers because it limited the number of employers who could actually be deemed to be a joint employer. The Biden administration came in and they said, this doesn't actually make a lot of sense. In practice, there may be a company that is not actually directing substantially what the person does every day. But in practice, if you actually look at how this working arrangement is, they're actually the ones in charge, and they should be deemed to be the joint employer. And so that was actually pretty quickly struck down during the Biden administration. And there was a period of time where no one was really sure what was going to happen. No one knew, since that was struck down, does that mean we revert back to the Trump administration standard, or really what is the rule? And in the last month or so, the NLRB actually issued a new finding, which reinstated the prior joint employer standard from the first Trump term. And so just to be totally clear about, with all this bouncing back and forth, the current standard is that the company must exercise substantial, direct, and immediate control over the worker. Mm-hmm. We no longer have that kind of loosey-goosey Trump-Biden administration standard saying that it doesn't matter whether they actually control the terms, just if it has the effect of it.
Okay, well, I'm sure this is really important to a lot of employers, but I can't. It's hard to wrap my head around when it really matters, other than like the PEOs that you might contract with somebody and say, you guys do all the payroll, but we're really the employer. That seems pretty clear. I think a lot of nonprofits do that, the smaller ones that don't have an HR department and things like that. But otherwise, if you're just a charity that hires someone to come on site and do something, maybe the place to address this is in your services agreement with the employers, to be very clear that the contracted party is the one that is the employer of its own employees. And I think that's pretty standard in our form services agreements.
That would be pretty standard. Another circumstance that I could see it happening, and maybe applicable to larger nonprofits rather than the smaller nonprofits, is, if you were contracting with another company to provide, let's say, janitorial services, and those people are coming in, even though they work for the other employer, they could be deemed to work for you if you set their hours or if you're the one directing what they do.
Mm-hmm. Okay, well, at least there's clarity. It sounds like this is overall a good development for employers. I
think that's right. Yeah. This joint employer standard is considered to be much more favorable to employers.
Okay, so then the court case that you wanted to talk about, what did our California Supreme Court do recently?
Yes, so this is applicable to wage and hour class actions, which it doesn't happen all the time for nonprofits, but I have seen nonprofits hit with wage and hour cases. So this would be applicable to any nonprofit, in particular, because most nonprofits, one of their key defenses to a wage and hour case would be the good faith defense. And that basically says, okay, even if we did something wrong here, our intent was to follow the law. We thought we were following the law. So even if there's some penalties here, we shouldn't be imposed, anything above what these individuals are owed. For example, there might be punitive damages or other exemplary damages. For a long time, the standard has been, if you had a good faith belief that what you were doing was lawful, you would not have those additional penalties imposed. This year, the California Supreme Court came in and said that that's not exactly the right way to look at it. They said that the employer actually needs to show that it did something to try to understand whether they were working lawfully. Now, what they left really vague is, what does that mean? Does it mean you're running a Google search to say this is okay? Does it mean you're going on OpenAI and asking OpenAI if your practices are okay? The Supreme Court didn't want to wade into that. There's just too many considerations. But what's clear is that you can no longer just rely on kind of a automatic belief that what you're doing is okay. You would need to show that you did something to try to learn. And ideally, employers would start to keep some kind of record of what they did to understand that in a non-privileged context. Because you don't want to have to rely on a communication from your lawyer saying, well, there's all these risks that you should consider, but on the whole, this is probably fine. You would probably instead want to rely on something from your HR team or another internal actor showing that there was some sort of review done to ensure that there was a good faith belief that the conduct was lawful.
And so this is, just to back up a little bit, this is those claims that can get pretty pricey because it's a class of current and former employees over things like we didn't get our meal breaks on time, or they made us stand in line before our bags got searched. I think that was a big case. Things like that, those practices that may seem innocuous when you're trying to run a business, but are actually highly regulated in California.
Exactly.
Yeah.
Meal and rest breaks, overtime. So anytime worked over 8 hours a day or 40 hours in a week, or employees who claim that they were misclassified as exempt.
Right. That's another really big one.
Yeah. If that were to happen, then all of a sudden, people you thought were exempt would have all sorts of wage and hour claims.
Yeah. Okay. Well, that's a lot of new stuff to keep in mind. Any other closing remarks for our nonprofit employers in this new environment? I know there's so many different ways employers need your attention, which is why I call you so often.
Yeah, absolutely. One thing I'm reinforcing to all my clients right now is that there's so much going on with the federal government and what the federal government is doing. But it's just really important to keep in mind that California law is still trucking along and doing the same thing California law always does. So, I saw a headline the other day saying that, the Trump administration is not interested in transgendered employees and which bathroom they think applies to them. And they're not going to consider people's gender identity in those types of considerations. But it's, this is just a representative example, but it's important to remember that in California, there's still a significant weight towards protecting the employee, and particularly with respect to historically disadvantaged groups. So even if the Trump administration is saying, they're not interested in gender identity, California certainly is. And so it's important for employers not to get distracted by what's going on the federal level and forget to comply with what California law says.
Okay, so that's a great way to wrap up. Thanks so much for being willing to talk us through this again this year, Ben, and we'll see you next year, or maybe we'll have to even do a fall update if there's a lot of legal changes. But maybe, hopefully we can hold off and pull you back in 2027.
Well, I was happy to join. Thanks, Cynthia.
Great, thanks so much. So with that, we're wrapping up our episode 154. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource brought to you by the Exempt Organizations Group at Varela, Braun & Martell. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.